first case to come before the court is DeMoss versus Village of Silver Lake. Both sides ready to proceed?
You share this one.
And each side will have 15 minutes, and the appellant may reserve up to 5. And I will keep time, and you will let me know if you want to say anything. Thank you.
Thank you. May it please the court, Your Honor. Attorney Larry Shinextor with the appellants, and I'd like to just reserve just 3 minutes.
That's fine. Thank you.
Actually, Your Honor, I've never stood before the court actually in this position before where so many of my objections to a magistrate's decision have been sustained, and yet I stand here as the appellant. So I'm trying to piece this together. Actually, we've only assigned one error before the court, and that's that the 1995 statute of the Village of Silver Lake, which amended the 1976 statute, was applied retroactively, and in doing so, it was applied retroactively unconstitutional. The first point I want to make is that a statute is automatically presumed to be prospective unless there's some intent within the statute to make it retroactive. I think the trial court skipped that issue, and I pointed that out on page 5 of my brief. And I think that's one of the major issues I have, is that had the trial court made that one analysis, the whole thing might have ended right there. I think that in and of itself is enough for remand, at least on that issue, for the trial court to make the proper analysis under the Supreme Court decision of Belot versus Belot, which is contained in my brief, I believe, on page 4. Now, even that, with the Belot decision, if you get past the issue of whether the statute could be applied retroactively or not, by just the one-part analysis, then there's a two-part analysis. Either the statute, if it's found that it could be applied retroactively, or there was intent to apply it retroactively, which I assert there wasn't. But since the trial court has not made that decision, I want to move on with the two-part analysis. Since, as I said, the trial court hasn't made that assertion, move on. Once that first part is satisfied that there was intent, and again I assert there wasn't, but they have to determine whether that statute affects either a substantive right, a vested right, takes away some kind of, or imposes some kind of new duty or whatever, or is just remedial in nature. That's under the test, the two-part test under Belot versus Belot that I mentioned earlier. Now, in this case, what we're talking about is health care benefits and life insurance, more of the health care than the life insurance issue. Under the 1976 statute, retirees who obtained 15 years of service, once they retired under the Ohio Police and Fire Pension Fund, they were entitled to payment of their health care benefits. When the 1995 statute was enacted, that clause was removed. 4 appellants that I represent at that time were the only 4 that had reached the 15 years of the period of accrued time. Our assertion is that that 15 years, those 4 appellants had vested their time. If nothing else, they had the vested right. Even if we go back to the intent issue, they had the vested right at that point in time.
Were any of them eligible to retire before 1995?
Pardon me?
Were any of them eligible to retire before 1995?
No. None of them were. Okay. But even if we not skip, but even if you look at the other part of it, substantive accrued right. Well, they accrued to 15 years, there's no issue there. And it is a substantive right. It's not just a procedural, formal right. It's healthcare has to be considered a substantive right. It can't be considered just a, as I said, remedial right, substantial right. Procedural right. It has to be considered a substantive right. So under the two-part test, if it's not a vested right, then it's an accrued substantive right. So either way, that statute has been applied retroactively and constitutionally, either under the single part test, because it was never meant to be applied retroactively, which I'm asking for remand for the trial court to decide on that issue, or under the two-part test, whereas it possibly could have been applied retroactively, but even if it could be applied, then it didn't meet the second prong of the test because it took away that vested right, or it took away that substantive right for of being the health care. So that's all I have for the court. So I'll reserve the rest of the time.
Thank you.
Thank you.
May it please the court. My name is Frank Skeldone and I represent the village of Silver Lake. This court must affirm because the 1995 ordinance applies only prospectively and the village can change its policy. We look to the ordinance to determine these matters, and absent some clear indication that the legislature intends to bind itself contractually, the presumption is that the law is not intended to create a private contract or vested right and merely declares the policy to be pursued until the legislature determines otherwise. There's no language in the 72 ordinance indicating a vested right, and the requirements of the 72 ordinance were not met in the first place. The 1995 law is being applied prospectively. It only applies to employees that are retired and that have 15 years of service. So these employees had not yet retired, and further, the plaintiff DeMoss retired in 2010, plaintiff Kennemuth has not yet retired, plaintiff Harrison retired in 2012. An employee's right would only vest upon receiving the benefits, or in this case, retiring after 15 years. None of the employees retired when the 72 law was in effect, so it's a prospective application of 1995 ordinance. The 1995 ordinance does not go back in time and take any benefits away. I mean, it doesn't take any accrued benefit away from them. It doesn't take any salary. It doesn't take. They haven't met the necessary hurdles to achieve that benefit. Ohio law provides that an employer can cancel insurance benefits who are still working and not retired. What plaintiff is arguing in this case essentially is akin to a promissory estoppel claim or a detrimental reliance claim, which the court is well aware. In 9th District precedent provides that it isn't a claim that can be brought against a political subdivision. I mean, at its heart, I mean, the argument that's being made here really is that, I mean, I suppose all laws can be characterized as retroactive to some extent. If we merely mean that, well, you'll be surprised if a village council or a legislature changes its policy, not unlike a tax law where you buy a house and the taxes are at such point, and then later the council or there's a change in the law and you have to pay more taxes. But there's no, the 95 law in this case applies completely prospectively. So the analysis that opposing counsel is making really does not apply. The magistrate's report, despite what the argument has been, the paragraph 10 of the magistrate's report expressly stated that the 95 ordinance was not retroactive in effect. It expressly states that the plaintiff's contention was inaccurate and rejected. So these...
I was going to ask you about that.
Yes.
Because he does, make the argument in his brief that that the trial court really didn't address the issue of retroactivity. And you replied in a way that I didn't quite understand. I understand what you just said there about the magistrate, but in regard to the objections.
Yeah, the specific, you're right. What is, the response is, because the ordinance is being applied prospectively, it really doesn't apply. The plaintiff became entitled to the benefit of the 72 ordinance was just a mere expectation. The plaintiff had not retired when the 95 ordinance became effective. So there was no vested or accrued right at that point.
And isn't there a Supreme Court case on that point?
There is one, the Shealy case, in a private context, held that Ohio law provides that an employer can cancel insurance benefits who are still working and not retired.
Strictly in private.
No, I think it apply, I think that generally, I think that that would apply across the board. Because again, there was nothing in the ordinance that created this, nothing more than an expectation, or nothing more than an expectation, but not a right, nothing that was guaranteed to them. You can look expressly at the language itself. And there's another case,
But,
Doe versus,
I'm sorry,
no.
but in regard to my question, you were answering that in regard to what the trial court did in analyzing the retroactivity.
Right, but the trial court again found, in accord with that, essentially that this was a policy decision and relied on the Gamble case, but I think that supplies that absent some clear indication that the legislature intends to bind itself in a vested right or a contractual, the presumption is the law doesn't create a private contractual or vested right, but merely declares the policy to be pursued. And the court found, if I recall correctly, that it was being prospectively applied. So that analysis, I don't believe, applies. The Supreme Court in the Doe versus Ronan case also supports that, in that there was a new law that required background checks, and this didn't, and the employee who was a 20-plus year employee had gone to prison for drug trafficking 20-plus years ago. And the court found that the background check, when the background checks were initiated under the new law, that they found that they had this felony conviction and they had to terminate him. The court found that the employee was not eliminated, it was not a retroactive application of the law, and that he could be terminated. And there's even a more stronger situation where you have an employee over that long period of time, but still there's no retroactive application of the law, and that's Doe versus Ronan, 127 Ohio State 3rd, 188. Unless the court has any additional questions, we would ask the court to affirm the trial court's holding in favor of the Village of Silver Lake.
Apparently not, thank you.
Thank you very much.
I've only got a response to one point the council made. I don't disagree that the statute in essence is being applied prospectively as far as when they take away, when the retirement happens. However, they put a specific number of 15 years. Once they reach that plateau, that's the argument, that those 4 people, once they reach that plateau, I'm sorry, 3 people, once they reach that plateau, they had a vested right. It's no different than the police and fire pension fund when an officer reaches that 10 year. They got a vested right. If they don't go to the 25 when they get their full pension, they still have a vested right in some kind of pension or benefit. It's no different. If there wasn't a number on there, if it just said you get health care benefits when you retire from and go to the police and fire pension fund or whatever, but it didn't say you have to have 15 years of service, I can understand exactly that would be a full application prospectively, because they hadn't met that hurdle of retirement. But they set that specific plateau telling these guys, if you come to work for us, and if you work for us for 15 years, we're guaranteeing you that once you reach that 15 years, you're going to get your health care.
What if they go work what if they get in there, say they work 17 years, and then decide I'm gonna go work for Marks for a few years? Do they still get their?
No,
it's a
they have to
vested
be,
interest,
no, they would have had to been working for the village. That's,
when they retire.
yes, yes. It wasn't that they could leave and go to Cuyahoga Falls or Akron or whatever. If they weren't working for the village, no. So that's my issue, not that it's just that number they put specifically. Like I said, you come to work for us, you work 15 years, that's going to be your benefit. but now we're taking it away. Thank you.
Gentlemen, we will take the matter under advisement and issue a written opinion that will be sent to both